Hey, fans of freedom and open discussion, I'm heading over to Substack, and there's an ad-free audio and video version of The Adam Carolla Show that's going to be waiting there. In the near future, you'll even be able to watch ACS Live, unedited, as we record it, participate in the show via live chat. That'll be coming up very soon. You'll also get an ad-free version of the Adam Carolla and Dr. Drew Show. You'll also get an exclusive to my new podcast, Beat It Out, where I share unpolished ideas with my comedian buddies. The first series of episodes is going to be Jay Moore. You'll get all this and more for the low, low price of $9 a month, a pittance for all we're going to bring you. Subscribe now at adamcarolla.com/Substack, and I'll see all of you in our new speakeasy called Substack.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my therapeutic co-host, Brett.
You know, Alice, I feel like every one of these episodes is a therapy session, so it's always good to join you.
Actually is.
It is.
You know, that's not where I was going with this, but when you say that, you know, someone the other day was like, what's an unintended benefit of the podcast? I was like, free therapy?
Yeah, free therapy, exactly. Get to talk it out.
Brett has to talk to me about it. And then you guys, I mean, you don't have to listen, but you do listen. So it's great. It's free therapy. But speaking of therapy, we previously talked about this case after the oral argument in this season of SCOTUS, and a big opinion has dropped in a case about Colorado's law regarding talk therapy or conversion therapy. And we were right and we were wrong. We are always here to talk about where we were wrong. We were right about the result, wrong about who would come out on which side of the result.
Yeah, and this case is called Childs versus Salazar, and it's about conversion therapy, as Alice was saying, either sexual orientation or transgender issues, anything along those lines. And Colorado had passed this law that we're going to talk about at length, banning that kind of therapy. It's kind of vague, but generally speaking, that's what they were doing. And goes up to Supreme Court. We had predicted this would be 6-3 along the sort of ideological lines as traditionally defined. I truly believe this is a 3-3-3 court, but we thought the 3 in the middle would go with the 3 on the right, and the 3 on the left would want to uphold the law. Turned out it was an 8-1 decision, with the 6 sort of traditional conservatives. Then you had Kagan and Sotomayor joining them, and then the lone dissent from Justice Jackson. And I will say this, when we first discussed this was one of, I think, the 5 cases we discussed in our preview of this
season of SCOTUS. And honestly, it seemed pretty straightforward to me that this was going to be overturned, that Colorado went too far. Justice Jackson's dissent is much more persuasive than I expected. We're going to talk about that in a second. This is an interesting case when it comes to the First Amendment and how the First Amendment works. But let's talk about the opinion and talk a little bit about the issue. So this was a Gorsuch opinion. And Gorsuch, it's interesting the issues that each judge has. So Gorsuch really likes a few things. If there is an opinion about Native Americans, he's going to either write the opinion or he's going to write the principal dissent. He's really into he was in the 10th Circuit before this, which covers a lot of the country where there are tribes. And
tribes love him.
And he's very good on the issues. He knows these issues. Honestly, they're tricky issues that come before him, but he lived in this area, and many of these cases came to him in the 10th Circuit.
And during his confirmation fight for the Supreme Court, he was endorsed by a lot of the different tribes, which is a little unusual, but he got their endorsement, and they were right on him. I mean, he wrote the Oklahoma case, which we've never talked about. We should, because it's fascinating, about
tribal land in Oklahoma. He always does that. He tends to do a lot of religious liberty cases when they run into some sort of government regulation. He writes those. So that's what he's into. Free speech is right down his alley. So it's not that surprising that he's writing this opinion. But he writes the opinion for the majority of 8. So Childs is a therapist in Colorado, and she offers something called talk therapy, which is when you think of sort of the person lying on the couch and talking through issues, that's what she does. She's not prescribing medication. She's not doing any kind of
medical experimentations.
Exactly. No electroshock therapy, nothing like that. It's literally just talk therapy. And this includes reducing or eliminating unwanted sexual attractions. So this clashed with Colorado's law banning what has been called conversion therapy. So as the court describes it, so this is how Gorsuch describes this. Colorado's law allows her to affirm a client's sexual orientation, but prohibits her from speaking in any way that helps a client, quote unquote, change his sexual attractions or behaviors. So basically, the way this has been described in the sort of straw man-y type arguments is this is, a parent is forcing their gay child to go to this therapy, and she would berate this person until they no longer thought they were gay. It's sort of the nightmare scenario, and is often the scenario presented whenever these kind of therapies are banned. Her examples in her brief that she's experienced were things like someone comes to her and says, hey, I've been having these attractions. Maybe I've been having same-sex attractions. Not something I want to have. I want to talk through this with you, see if I can get to the bottom of it, see if I can get past this. I don't want this, right? And so she'll have those conversations. Or maybe someone comes to her and says, hey, I've been struggling with feelings that maybe I'm transgender, don't really know what to do, don't really know which way to go. And under the law, she can't have that discussion with them. She basically would have to say, well, I can tell you why maybe you are transgender, but I can't discuss why you might not be. The law would prevent me from doing that, and I could get in a lot of trouble if I discuss both sides with you. I can only discuss one. There are probably people out there, including maybe Colorado, who would quibble with that and say, well, it wasn't quite that restrictive, but the problem is the law itself is very poorly written, as we often see in these cases, very broad. I was actually surprised that the court did not address a vagueness issue with this, because vagueness issues, whenever the First Amendment are implicated, are usually a pretty big deal, but they don't really address that. They just assume it's not vague, which I think because they want to get to the actual issue.
Just by the way, the vagueness issue, this isn't the only state that has a law like this. So I think there is also a reason for wanting to get to the actual law, because
like 25 or 26.
25,
that's a
half
lot.
the states. Yeah, like half the states have this conversion therapy law like this. And so I can imagine that they couldn't really dodge this question. They can dodge it today, but it would come back in the form of either another state, or there'd be more confusion over it. So there is a reason for them wanting to get to it, because this is not a one-off. Now, if this were a one-off, I can see them, I think this case is much more clear than perhaps another law that's better written, but I can see them perhaps talking about the vagueness and whatnot. So I think the background, kind of the lay of the land, is also important here. We're talking about half the states having a law like this, and this is going to have ramifications well beyond Colorado.
And so we have a situation here, and everyone agrees on this. So we're in the First Amendment area. So traditionally with the First Amendment, there are things called content-based restrictions and viewpoint-based restrictions. So a content-based restriction, the court often applies a less serious scrutiny. We'll talk about levels of scrutiny in a second. To those, basically that says, hey, you can do whatever you want, but this issue is off limits. You shouldn't talk about that, right? So for instance, you might have an example of content-based restrictions. We have a neighborhood. You can put anything you want to in your neighborhood, but no flags. We don't allow flags. No flagpoles, no flags. Not telling you you can't have an American flag or a Ukrainian flag or a pride flag. We're telling you can have no flags whatsoever. So that might be a content-based restriction. A viewpoint-based restriction is flags are fine as long as it's not a pride flag or an American flag or Confederate flag or whatever flag you don't like. You can't have that one. That would be sort of a viewpoint restriction. So everyone agrees here. And viewpoint restrictions, by the way, very heavily restricted. One of the things that the court has said the First Amendment really does not like is when the government says we are banning a certain viewpoint. And if you're going to do that, there are these levels of scrutiny. That would be under strict scrutiny. And generally speaking, strict scrutiny, to survive that, you have to show that your regulation is narrowly tailored to protect like a
compelling government interest.
A compelling interest, that's what it is. A compelling interest, and it'll work. We've talked about this before.
Yeah, most tailored way of doing it.
Most tailored way, narrowly tailored as possible. There's really no other way to do this, so this is how we're going to do it. We've talked about this with gag orders. So the compelling interest there is protecting the rights of the accused. The narrowly tailored way to do that is a narrow gag order on the most narrow group of people possible to prevent information from getting out to the public that would hurt the accused rights. And so what we often see is when those get struck down, as has happened in several cases that we've talked about, it's because they're too broad. They're not narrowly tailored, as Alice said. So everybody agrees this is a viewpoint restriction. Everyone agrees on this because as the therapist, you can express support for transgender if you want to become transgender.
The expressed attraction.
Exactly. You can express support for it, but you can't be on the other side of it. If you express any kind of reservation about that or suggestion that that's not what you want to do or that's not something you should do, that is banned. So we ban that viewpoint. We allow the other viewpoint. Everyone agrees on that. The question is, because this is in the area of therapy, well, number one, what level of scrutiny should we even apply? Because some people, including all the lower courts that had addressed this, the district court in Colorado and the appeals court in the 10th Circuit, had said, because this is professional speech, you're not just out in the world expressing an opinion, but you're doing it as a therapist. Because of that, it's only rational basis. And rational basis means
you trip over the rational basis, what I always say. The rational basis is the lowest, obviously. Intermediate is the middle. Strict scrutiny is the highest. Rational basis, basically, if you can say it, if you can dream up a reason, that essentially meets rational basis. It doesn't even have to be the real reason, as long as you can articulate a reason.
Exactly. As long as there's some reason out there to do it, you can do it. One example I've heard before about something that might fail rational basis, but this is an example of how broad rational basis is. We want to encourage kids to take their vitamins, so we ban guns. So we ban guns because if we have guns, people might buy them, and then they might use them, and that might kill a child, and then that child can't take their vitamins. So therefore, in order to encourage more children to take vitamins, we ban guns. That's a lot of leaps. Is there a rational basis for that? I don't know, but that's how broad rational basis is. You're like, that seems like a leap there, guys, but maybe. So generally speaking, the view has been, if it's rational basis, the restriction survives. If it's strict scrutiny, it doesn't. It's almost a shorthand for this is going to be struck down. So in this case, for instance, a lot of people have said that the Supreme Court struck down Colorado's law. They didn't actually do that. They're only deciding what scrutiny should be applied. The lower courts applied rational basis, and the 8-1 decision says, no, you should apply strict scrutiny.
And that's a great point. So a lot of these legal fights are not actually about the specific asking the court to do something, but saying what standard of review applies here. And when they say the standard of review applies, what they then do is send it down to the lower courts to say, now apply the correct standard. But we all know that strict scrutiny has to be narrowly tailored to a compelling government interest. And that is such an incredibly high standard. And they also suggest in their opinion, look, it's not going to survive strict scrutiny. It's not even a close call here. So this is what the court said in their holding. The question before us is a narrow one. By the way, the court, no matter what they do, they always say whatever they're going to do is narrow, which I really love. It's like a turn of phrase at the Supreme Court. What we're asked to do is something super narrow. This is part of the court is the least dangerous branch. And it is. It's supposed to just interpret what's right before it. So I just like it how, I bet if you did a search of the question before us is a narrow one, it probably pops up if you had a word bubble, one of the largest words within your word bubble. So they go on to say, Ms. Childs does not question that Colorado's law banning conversion therapy has some constitutionally sound applications. She does not take issue with the state's effort to prohibit what she herself calls, quote, long abandoned aversive physical interventions. Instead, Ms. Childs stresses that she provides only talk therapy, employing no physical techniques or medications. By the way, what they're doing there is drawing that distinction between, is this just the practice of medicine or does this fall into free speech, right? When you're taking away the medications and the physical interventions and we're saying, we're just talking. This is how, first of all, Childs is arguing at the Supreme Court, but what the court is doing here to explain, because you'll see in Jackson's dissent later, it matters, right? If this is just your professional therapy, medical opinion versus free speech protected under the Constitution. So the opinion goes on to say, yet she argues Colorado's law still applies to her, prescribing what she may say in, quote, voluntary counseling conversations with her clients. And because the application of the law strikes at the heart of the First Amendment's protection for free speech, she contends it warrants considerably more searching scrutiny than the rational basis review the 10th Circuit applied in this case, or the intermediate scrutiny review some other lower courts have employed in cases like hers. We agree. So right there, they're saying rational basis that the lower courts in this particular case, wrong standard. And by the way, remember how there are 25 other laws kind of like Colorado's? This has percolated through other courts as well in other circuits. Other courts have chosen to apply intermediate scrutiny, and they're saying that's wrong as well. And what's left, of course, is strict scrutiny. So the Supreme Court held that strict scrutiny applies, and then they send this case back to the lower courts to apply the strict scrutiny standard to Colorado's law, implicating very heavily that it cannot pass strict scrutiny.
Yeah, so that's essentially their holding is, hey, this is not surgery, it's not prescribing drugs, it's talking, and that's what the First Amendment protects, and so therefore strict scrutiny applies, and they send it back. And well, that's what they say. We'll talk more about that majority opinion as we talk about the dissent. Before we get to the dissent, though, there's a concurrence between Kagan and Sotomayor. They join in this concurrence, and they note, yeah, this law was doomed to fail. It's not viewpoint neutral. It expresses support for one viewpoint over the other, and you just can't do that. At least, certainly not under rational basis review. This is going to be under strict scrutiny, and that's not going to make it. Now, their concurrence is there for a couple reasons, because there is this sort of, I feel like, internal battle on the Supreme Court. I mean, this case is interesting almost more for what it says about the Supreme Court. I mean, the case is interesting too, but so on the left side of the Supreme Court, Kagan, Sotomayor, and Jackson, I think there is a real disagreement on how best to address questions like this and how best to oppose the majority view. And Jackson's view is much more revolutionary. She's much more Winston Churchill. We got to fight them in the hills. We got to fight them on the beaches. We got to fight them everywhere, right? Kagan is much more reserved when it comes to this. She's much more like, no, we have to honor precedent. We really have to think about the consequences. And this consequence that she's concerned about is if you allow to choose viewpoints, if the state can do that, if they can pass a law that allows them to say, you can speak this viewpoint and not the other one. There are 25 states, 26 states maybe, that ban conversion therapy. What if another state says, well, we're going to take the opposite view. We're going to ban any talk therapy that encourages someone, if they have same-sex attractions, to embrace those, or if they believe they're transgender, to embrace that. We're banning that. You can do conversion therapy all day long, but you can't do the other side. If that is within the power of the state regulating medicine to do, then all these other states could do that. And it would be legitimate because we've said viewpoint neutrality doesn't matter when it comes to medicine. And I think Kagan and Sotomayor strategically are much more concerned about that than they are about Colorado's law. And I think practically speaking, this makes sense because Colorado's law is based on the AMA and the American Psychological Association and all these other big groups. They support this. They don't like conversion therapy. I think Kagan probably figures most therapists, most psychologists, most doctors are not going to do this anyway. We don't actually need the law. But there's a real concern that in states that take a different view than Colorado, that they could ban this, that they could say, no, sorry, American Medical Association and APA, we're going the opposite way. I think she's much more concerned about that than she is about some rogue therapist in Colorado. So she says, hey, you need to think about this before you say this, because even if you support what Colorado's doing here, you're opening the door to something else. And she takes swipes at Jackson, and she has a few footnotes where she does this. And she basically says, look, the way you're looking at this, you are collapsing this distinction that we talked about earlier between content restriction and viewpoint restriction. And Kagan's basically like, look, if Colorado wanted to say, just as a talk therapist, this is just not an area you can touch. You don't offer therapy on this. They could do that, but what they can't do is pick a side. I don't know if that's necessarily a better approach, but nevertheless, I think for Kagan, that concern about what the other side could do is much bigger than the Colorado case. And so she goes at Jackson on this point.
And look, practically, this is not a hypothetical that is like so far out there. 25 states, I think it is exactly 25 states have this same law, meaning likely there's almost an equal amount on the other side who have not adopted this and may, in the face of if Jackson's opinion were adopted, to adopt the opposite, right? And so this is not some hypothetical that is so far out there, but it's a very real reality that could kind of collapse this entire distinction, which has real ramifications beyond just talk therapy.
So Jackson writes a whale of dissent. So the majority is somewhat lengthy, but not that long. The concurrence is just a few pages. Jackson's dissent is longer than both of them, and she really goes into this. Now, she does something that I hate when she starts. Now, I like to talk about this when they do this. I hope to shame them out of this one day when they start listening to our podcast. So you remember how the Chief Justice in the tariff case did the whole, like, 2 words separated by 26 others, and it's like, what are you even talking about? That's not actually your position. You're doing that just for some sort
Flourish.
Yeah, flourish. I didn't like it. Well, Jackson does the same thing, but I think it's worse for her, actually. I think this is really bad, but I'm going to read you. This is how her opinion starts. And I want you to think about if what she's saying were literally true, what it would mean. Here's what she says. She starts with a quote. There is no right to practice medicine, which is not subordinate to the police power of the state. Lambert versus Yellow Lay. From 1926. There's a lot of water under the bridge since 1926 about this particular area. She goes on to say, that was true 100 years ago, and it should be true today. So think about what that means. If that's actually her position, there's no right to practice medicine which is not subordinate to the police power of the state.
So, first of all, police power of the states.
Are unlimited, basically.
Unlimited. So in other words, it's the states or... Right. So politicians who are not medical people have to be able to dictate how therapy and the medical field is conducted.
Or, so can states ban birth control? If that's the rule, we're going to go with.
I mean, it says there's no right to practice medicine which is not subordinate to the police power of the states. Can they ban appendectomies?
I mean, I assume they could ban birth control, appendectomies, abortion, any kind of psychiatric drugs if they wanted to. I mean, they could do anything.
They could ban C-sections. Like everyone, no matter for medical purposes or not, like if it doesn't come out the regular way, then like you're out of luck because we think C-sections are pushed on people. That's unnatural. And in fact, we think it's pushed on women. So by the way, I'm someone who's had multiple C-sections.
And you might think, well, that's silly. That's a straw man because obviously the rights protected by the Constitution would trump that. Well, no, that's the whole point of this.
We're talking about the First Amendment.
The First Amendment and whether or not the rights in the First Amendment, how they are balanced against that police power of the state and the state can do. So if you're going to take a full-throated view that the state can do whatever it wants when it comes to medical care, regardless of what the Constitution says, you have opened up a huge can of worms. And I think it's interesting. That's a 1926 opinion. And it's from a period in the court's history when the power of the state to compel medical treatment was basically unlimited. 1 year later, the court would release Buck v. Bell, which is one of the most infamous cases in history that endorsed forced sterilization because, as Oliver Wendell Holmes, who deserves far more scorn than he gets, wrote, 3 generations of imbeciles are enough. So that's the court that's saying the right to practice medicine, which is not subordinate to the police power of the states. That is wild that she started this opinion with that, particularly when it's not even actually her argument.
Right. I think it's a shock factor, and I think it's a bad one because it undermines her position. So this is a long opinion anyways. That is just a floor. She doesn't continue down this route because she can't, because this is not her argument. She actually gets down to business later. So she says, stated simply, the majority has failed to appreciate the crucial context in which Childs' constitutional claims have arisen. Childs is not speaking in the ether. She's providing therapy to minors as a licensed healthcare professional. The 10th Circuit was correct to observe that there is a long-established history of states regulating the healthcare professions. And until today, the First Amendment has not blocked their way. For good reason. Under our precedents, bedrock First Amendment principles have far less salience when the speakers are medical professionals and their treatment-related speech is being restricted incidentally to the state's regulation of the provision of medical care. Okay, that is not laughable. This is the heart of the question, whether this is medical practice versus just pure speech. Now, this, I think, is a very compelling argument because we are not talking about Childs at home being able to express her viewpoints. This does not happen in the context of when she is off the clock, not a therapist, just at her church or at the grocery store. We're talking specifically about when she's speaking to a client in an industry where she has to be licensed under this law. So now I think this is actually a much more compelling argument.
And I'll say this. So I read this opinion and I expected to get from the majority a very well-reasoned argument about why medical professionals aren't different. You know, I expected to get like some explanation of how, like, yes, they're doctors and yes, they're engaged in medicine, but still, here's the reason. And I'll just tell you, it's not in there. Like, you can read it.
I was a little surprised by that, to be completely honest, because when this first went up to the Supreme Court, I was like, whew, like they're going to have to get over the fact that this is also within they can hide behind this is therapy. This is the medical profession. And who are we as non-medical professionals to dictate what is good and what is wrong, right?
And I'll say this. I mean, we're going to continue to read from her. I don't necessarily think she's right, but I've struggled some with why she's wrong. Because as she talks more and you try, like if you read the majority's opinion, it's weak. There are parts of it, like for instance, Gorsuch, he loves this example. He continuously goes to the F the draft example. So guy has a jacket on, it says F the draft on the back of it. He's walking through a courthouse, cop sees him, he gets arrested for that. He goes up to the Supreme Court. The Supreme Court says, of course you can say that. Of course you can have a jacket that says that. Just because it's profane, just because it's whatever, doesn't mean you can't say that. That has no bearing at all on this question. Completely different situation. If the Colorado law said, if you're a licensed therapist, you are not allowed to advocate for conversion therapy. You're not allowed to go to a political rally and speak and say, we really need conversion therapy. You're not allowed to oppose this law. If they said that, that would be like the F the draft. Then it's like, yeah, okay, of course, you can't do that. You can't tell her what she can't be for or against just because she's a therapist. But that's not what the law is about. The law is about what's going on in this therapy session. And the majority says it several times. And it's laugh out loud funny when they're like, well, I mean, it's not like she's prescribing drugs or doing surgery. She's just talking. That's all she's doing is talking. It's like, yeah, that is the medical care, is the talking. Like, so anyway, so she goes on because she's hammering on this and she's kind of got him and she's hammering on it. In my view, it is obvious that the MCTL, which is the law, is regulating professional conduct insofar as it prohibits providing a particular therapy. The aim of the statute is not suppressing speech. Indeed, Childs claims that her otherwise protected speech is being swept up by Colorado's otherwise valid treatment prohibition proves that very point. This set of circumstances seems to fit NIFLA's, which is a previous case, idea of a permissible state regulation of professional conduct that incidentally burdens speech to a T. So what she's essentially saying is what they're regulating is the practice of medicine, what she does as a doctor or therapist. And to the extent that infringes on her speech, that's incidental to the practice of medicine, whether talking is the medical practice at issue. And no one used this example, and I don't really know why, but to me, imagine you're a therapist and someone comes in and says, I'm having same-sex attractions, or I'm depressed, or, I think I may be schizophrenic. I mean, whatever mental issue they have. I think I'm bipolar. I'm having these strange thoughts. And they're like, well, in my experience, it's really hard to deal with that. You should just kill yourself. You should just commit suicide.
Something that may resonate with a lot more people that it's not so outside the realm of imaginability. Someone comes in and they say, I hate the way I look and I can't eat any food because if I put any food in my mouth, it's going to make me fat and ugly. And you can't say to them, that's a disorder. You can only affirm them and say, yes, I think you should never eat again. And I think that dropping 30 pounds within the next month is a fantastic goal. And I think you should continue to do that. Right?
And I feel like most people would agree
that's okay to ban.
The state can ban that. The state can regulate the conduct of doctors,
only
therapists.
In the context of that therapist.
Exactly. They can regulate that, just basic, or, it's like, this is not exactly the same thing, but it's like the pill mill doctors, right? I mean, the state can obviously tell a doctor,
you're
can't
not
just
allowed
prescribe.
to just hand out opioids.
Yeah, just because you're a doctor, you can't do that. They can do that. That's not burdening their rights. That's a little different. But nevertheless, I mean, I think everyone agrees the state can create minimal professional conduct guidelines about what you can say and can't say. You know where else they do it all the time? Lawyers. Are all the ABA's rules basically now unconstitutional? Because what's the difference between...
All we do is talk. I don't do medicine. I don't do physical interventions. All I do is talk. My job is to talk.
We're not even allowed to say how awesome we are in ads. We can't say, I'm so much better than Alice. Don't hire her. She's a scumbag. We can't do that. We're prohibited from doing that by the rules. That seems to be way less important than what a therapist says to somebody coming to therapy. So I just assume all those laws are now unconstitutional, right? Because that infringes my free speech.
Do you want to go challenge one?
We should. I mean, under this, I feel like they're all gone. And maybe they should be. I don't know. But the majority does not grapple with this at all. They just keep coming back to she's talking. I mean, she's not doing it. All she's doing is talking. And that, if she's talking, it's the First Amendment. It's free speech after all, and she's speaking. So therefore, and it's like, what about reasonable time, place, and manner restrictions? You can't say you have the right to say this anytime except in the hour-long block you're with your patient. That's not reasonable. Anyways, so she continues, she goes on. Yet the majority strangely suggests otherwise with the opinion it hands down today. The majority does this primarily by eschewing serious engagement with the interaction between NIFLA and Casey. These are two prior cases. Its workaround seems to be the First Amendment applies full bore here because Child's speech is being impacted. After all, she is a talk therapy provider. But when NIFLA's teachings are properly understood, this comeback is no answer. Yes, Childs happens to be talking when she's providing therapy to patients, but the MCTL regulates the provision of medical treatments by licensed medical professionals, which states are fully empowered to do. That Child's kind of medical care involves talk therapy is, in NIFLA's words, merely incidental. And let me just say this. You don't have to agree with her. She can be wrong, but the things she's saying deserve serious engagement. They deserve explaining why she's wrong. And no one does that, including the concurrence.
And here's the thing. So the way this opinion goes, of course, is that the Supreme Court says the standard you used is wrong, apply strict scrutiny. I wonder if at the district court we'll get actual more engagement here on what narrowly tailored looks like, because you can imagine there is a version of this law that could pass strict scrutiny. I don't think it's the version that currently exists, which is incredibly vague, but you can imagine kind of the things that Brett just said within a law does meet that compelling government interest. Let's say that you cannot, let's go back to the eating disorder example, just to make it less about this specific case, but like you can imagine that you cannot, based on our science and all these things, that this is very dangerous if you affirm the disordered view of eating that these people are coming in with. So for the specific patient who meets a certain profile within this hour, all these things, you can imagine that's narrowly tailored for these reasons. As this law is written, it's incredibly vague. I think it's really going to be difficult for it to ever meet. But I think they skirt this discussion because they don't engage with the strict scrutiny. They go, that's not before us. It's going to come back before us in another year and a half or so when the lower courts do their whole thing, and then we'll have to actually engage these very serious arguments.
So the majority, go read this opinion. I'm just curious what people think. Read the opinion, see what you think. So, one of the things that she brings up is informed consent. So doctors are required to speak certain words to you. If you're going to give a surgery, they have to explain to you everything that's going to happen. They have to explain to you why this bad thing could happen, and they're going to have to do this and all this other stuff. And if they don't do that, they can be liable for it. And so she points this out and says, hey, isn't that compelled speech? Isn't that a violation of the First Amendment? And I just feel like Gorsuch, he just sort of elides that by saying, well, yeah, but that's before a surgery. And, a surgery, if you don't do informed consent, it could be a battery because it could be a criminal thing. And so therefore it's different when it's that. And it may be a different situation, but it nevertheless is an example where the states can legitimately limit doctors' free speech rights because they're doctors. And even though you can differentiate that from this, it's just simply not the case that as a professional, you can't have your free speech rights limited. And I think that's just something they never quite grapple with. They never really, to my satisfaction at least, explain why this isn't at least somewhat different from just you're on the street having a conversation.
So Jackson goes on here, and this is the part where she breaks it down, and it is not addressed really by the majority. She says, to be even more specific, what we have here, of course, is the professional medical speech, right? And professional medical speech occurs when a medical professional speaks to a client in the context of the professional-patient relationship on matters within the provider's professional expertise as defined by the medical community for the purpose of providing medical care. That is exactly what Childs is doing here, right? She's not alleging that this is affecting anything. And that is how actually Gorsuch's opinion lays out the holding, is fitting it within this very professional medical speech context.
Yeah. And that formulation, honestly, I think the opinion's too long. I think her opinion's a little too long. I think she should have tightened it up some and really hammered on this. But that formulation is really good because time, place, and manner restriction, it's more like informed consent. It's more along those lines. One of the things I really did not like about the majority's opinion, I get it. Everybody loves originalism these days. It's amazing. It's terrific. Gorsuch keeps saying, if we're going to allow these sort of standards of how you should practice to guide the law and limit the First Amendment, they need to have sort of long-standing historical antecedents. And, the first code that limited what therapists could say or do or how they should practice didn't come along until the 1970s. That's basically originalism for therapy. We didn't really do talk therapy. The founders weren't sitting on each other's couches having discussions about their mental issues in 1776. Freud doesn't come along until the end of the 1800s. It takes a while for therapy to take off. It really takes off in the 60s and 70s. And then, of course, you have licensing boards and standards of conduct and practice and everything else that do come along in the 70s. And to act like this stuff from the 70s should barely even be considered because that's not ancient enough. I don't know. It just, the whole thing
the whole majority opinion is one of those where I feel like, and maybe this is what happened with them a little bit, I feel like they're right. Like, I feel like you can't have a law that so broadly limits and chills, frankly, what she can say in these voluntary sessions when people are coming to her and specifically asking her for help in this area. And it feels like telling her, you can't even talk about that. And if you do, who knows what you might suffer because of it. I mean, that feels very much like a violation of the First Amendment. But I do think you have to explain why it doesn't survive in a way that makes sense to the common person. And I'll just tell you, I think Jackson's argument for just the lay person out there is much more convincing. I think most people are like, yeah, you're a doctor. You're doing doctor things. You don't have all your First Amendment rights. It's like you're in the military, right? If you're in the military, you can't just say whatever you want. There are limitations because you're in the military. Doesn't mean you have no First Amendment rights. But, if you put on your uniform and do a TikTok on how your commanding officer is an idiot and the president should be shot, you're going to get in trouble. And like nobody's going to say, well, the First Amendment. Right? No, you're going to get in trouble. There's this natural feeling that therapists, doctors, they can't just say whatever they want. There have to be some limitations on it. But when you read Gorsuch's opinion, it's not clear that any of those examples we gave earlier, the anorexia example, the suicide example, anything like that, could be banned. The only thing I guess you could argue is that those are so bad, they survive strict scrutiny. But then you're really changing strict scrutiny, because up to this point, strict scrutiny has basically just meant it doesn't survive. Maybe you're giving some content to strict scrutiny, but I feel like you almost have to do that. And I understand Kagan's criticism of Jackson, because when you read it, I mean, she really does collapse the viewpoint and the content thing. It just doesn't matter to her that it's not content neutral. Like, she doesn't really deal with that much, but I don't think she thinks it matters. And that would have problems for her down the road. But I think Jackson's way of approaching a lot of this, I don't think she feels overly restricted by precedent. I think she thinks you should do the right thing in the case before you, and we won't worry too much about what else might happen. And I'll give you an example of that, because if she was really principled on this, I think it would be pretty interesting to see how that principle would develop. It's like Scalia with flag burning. Scalia would often use that as an example. He doesn't like flag burning. He wishes it were illegal. But when it came up before the court, he sided with the flag burners because he thought this is core protected First Amendment speech. Can't ban that, right? At one point, she cites Skrmetti in support of her argument, which is the Supreme Court opinion about laws banning transgender procedures, drugs for minors. So basically, you had states that said, look, no minors are going to get this. That got challenged. It went up to the Supreme Court. The states won. So she cites that in support of her whole, the states have this vast power to regulate medicine. See Skrmetti. Footnote. And then in the footnote, she says, of course, if they use that power to discriminate against transgender individuals in violation of the 14th Amendment, that would be an issue. And it's like, hold on. So when the unbridled police power of the state to regulate medicine interferes with a constitutional right in a way that you find troubling, then they can't do it. But when it interferes with the constitutional right in a way you're fine with, then it's okay. I mean, that's sort of the inherent weakness in her argument, is she's not consistent on any of this stuff. But honestly, I think one thing people do to their detriment, including Kagan and Sotomayor, is they underestimate Jackson. And I think they need to really learn to address her arguments head on. And I don't think they did that in this case.
That's fair. And part of it might be that, she's the junior of the of the three of them. But I think this particular argument, she makes a powerful argument, and maybe they're not ready to deal with it. Maybe it will come up. I think they'll have to at some point, but not today.
Yeah. And I think she's going to continue to be a fly in the ointment. I just think she's not worried about irritating Kagan and Sotomayor. She's not concerned about irritating other people in the court. I mean, I think
she has her views. Honestly, she kind of reminds me of like early days Scalia. So when Scalia first comes on the court's very pragmatic. Some people would say activist. And Scalia comes on the court and he says, he's got this whole theory of originalism, that the court should be constrained by the original meaning of the Constitution, and that statutes should be read based on their text, not based on what they were arguing about in Congress or whatever. That's the way we should decide things, and we should limit it to that. And at first, he just got no support. And there's a famous case, Morrison versus Olson, which was like this. He was the lone dissent. It was about the special counsel statute. And he said it was unconstitutional for all these reasons. Wrote this dissent. It's a famous dissent. And at the time, he's kind of in the Jackson scenario. He was a very fiery writer anyway, all alone. Sure, he was mocked for it. The majority doesn't really take up his arguments. Well, now, today, I don't know what Jackson would say because she's a wild card, but I think at least 8 justices of the Supreme Court would agree with him. I think Kagan and Sotomayor would agree with him now on Morrison versus Olson, because he sort of worked by doing this iconoclastic thing and going against everybody. He was able to build this legal movement. Jackson needs to figure out some sort of guiding principle, because right now I think it really is just kind of a let justice be done that the heavens may fall. It's very much in this case, this is what I think the right thing is. So that's how I'm going to do this. But I'm not really concerned about how this affects the next case or how it locks into our precedent. I think that's one of Kagan's problems with this. She doesn't like the fact that she doesn't explain, like, how do you even have what we've been doing on the First Amendment if you're right? She doesn't, and that's her weakness. But if Jackson can come up with some sort of plausible theory of the law as she sees it, I think if you're a left-leaning law student, you want to clerk for Jackson. You don't want to clerk for Kagan and Sotomayor. Kagan and Sotomayor are like the old
guard,
stuffy, old guard, traditionalist. They're worried about the institutions. Jackson, she's the revolutionary. And I think you see that in this opinion. So.
Well said, Brett. And I don't think it hurts to give it a name of whatever her guiding principle is going to be.
Yeah.
Because people have to understand it and get around it, right? And this is part of, I think, having seen them in argument, if you see like the number of words each justice has said over the past season of SCOTUS, for example, Jackson far exceeds, I think, any other justice in the number of questions and the number of words that she says from on the bench during oral argument. And there are times where I've watched Justice Kagan and Justice Sotomayor, actually Justice Kagan to both Justice Sotomayor and Justice Jackson, a little bit of an eye roll, like, all right, stop talking in some ways. Like, you're hurting our side of the argument here. Whether that's true or not, you see a little bit of exasperation because Jackson is there to fight. In the oral argument, you hear her questions in the sense she's coming and she's ready and she is attacking and not letting advocates off the hook when they don't answer the question that she's asking before them. And you see that in her opinion as well. But she's coming with full vigor. But I think the approach right now, like you said, Brett, is very much like all the way, definitely no compromises. This is how I see the law, and this is all the way to the logical ends in this case. But then when you leave that case, it's not exactly clear how that would apply in all instances, rather than just set it all on fire. And set it all on fire is not going to likely be what either Kagan or Sotomayor are going to attach onto, because it's not a guiding principle. I guess for some it might be. But it needs to be something more articulated than simply burn it all down.
Yeah, I'm interested to see how it goes. I think, obviously, if there's another Democratic president, I would expect in the next, presumably there will be one day, but if there's one in 2028, 2029, I would expect Sotomayor would retire. I think Kagan's in it for a little bit longer. It's going to be interesting to see if you're replacing Sotomayor, does the replacement look more like Kagan or more like Jackson? I don't know. It's just it's a long-term view of what the court's going to look like. But I don't know. I'm really fascinated by Jackson. I find everything she does be interesting. I think people dismiss her all the time. I just think it's a mistake. Because, look, read the opinion. Read the dissent. There are parts of it that are like, oh, come on. But the things that she points out about the majority's opinion, it's hard to argue with her. So, anyway. Well, there you go. That was our short 30-minute episode.
And by the way, just in case you were following this was going to be part of one of 3 things we were going to discuss in a news update. we're already on episode 2. So we're seeing that we're really good at being verbose sort of thing. But hopefully this has given you some insight into the important opinion and that you should go read it yourself, as we always say. And we're always going to follow up, especially when we're a little bit wrong about the outcome. Just a little bit. Like,
just a little
wrong
bit.
in kind, not in the actual outcome.
And I'll say this. I think I did not give Kagan and Sotomayor enough credit because I assumed they would kind of go along with, we agree with these laws in principle. So even if this law is a little wonky, we still think the state can do it. Probably could have done it better. Like I could imagine some criticism in the dissent, but still the state can do this. Because look, this is about Colorado's law, but I assume people will challenge all of those laws, all 25 of them on this basis. And some will probably survive and some will fail. So this is a big deal opinion. And I think it's going to be a huge deal for professional speech, like we talked about, lawyers, for instance. I mean, unless what you're saying is a crime, unless it's fraudulent, how can you tell me? How can you restrict my advertising as a lawyer? I don't know. Anyways.
I don't know. Maybe you should buy an ad against me
hour.
saying that you're way better than me, that Harvard trumps Yale all day long, and then we can take it up.
There you go.
And then we'll take
and
it
then
up.
You can file a bar complaint.
And you'll get disbarred, and then you'll file. There, boom, right there.
And then
And then we'll podcast the whole time.
Yeah, there you go.
Well, guys, I hope this has been informative. We're only in April. A lot of opinions coming out all the way till June. So many. This is just the beginning. This is the slow trickle of what will end up being a very always exciting season of SCOTUS, and we'll be here for it. Let us know what you think at prosecutorspod@gmail.com. Follow us on all the social medias. Let us know what you want to hear about, because there's a lot of news, especially when you don't cover them fast enough, Brett, and it just piles up. We have a lot more we will cover. Is there anything else you'd like to add tonight on this beautiful Friday night?
We do have to stop talking so much. We got to rein ourselves in, because you're right. There's way too many things to talk about.
There's so many things to talk about.
Only do one episode a week.
Or just do more episodes, I guess.
So
do that?
I do have an announcement to make, I guess.
It's a big one.
It's a big one. Yeah. So the podcast is now completely defunct. You know, we've called ourselves the prosecutors this whole time, even though Alice is not a prosecutor anymore. And today was my last day with the department. So I am also, as of now, I don't know if I can get till midnight, am also no longer a prosecutor. So we got a podcast called The Prosecutors and 2 lawyers who don't prosecute.
Maybe it needs the parens. We were the prosecutors.
Maybe.
No, it's a really big deal. Thank you for your service to the American people. I really do mean that. Like, it is a labor of love to do it for that long. And let me just tell you guys, you don't do it for the glory, because there is none. You don't do it for the money, because there is none. You don't do it for the easy lifestyle, because it is not easy. But you stuck it out for a very long time. And hey, who knows what the future holds? Maybe we'll get to prosecute again together one day.
Maybe we will. We'll see.
Well, congratulations, Brett. I know that there are a lot of, I know the entire office is crying. I really do.
It was bittersweet. It really was. I mean, I felt like now was the time, but like you said, I've been doing this, been in public service basically my whole career, which has gotten long now. It's 18 years of public service, which is kind of shocking to think about. It's crazy. I've been a lawyer for 19 years, but yeah, so it's kind of scary to leave the bosom of government, to stop suckling at the teat of the taxpayer. But that's what I'm doing for now, at least. We'll see what happens.
Well, Brett, the next one, when we say we are the prosecutors, today you can still say it, but don't cry, okay?
I won't.
But we're very proud of you. And don't worry, this podcast is still continuing. In fact, there's more, maybe time to continue this podcast because you don't have to run off. You know, I went to go text Brett to say, congratulations on a last day, and it's a big day. The last text right before that was, hold on, I'm on a work call. So thank you for all you've done. And don't worry, guys, we will still be here to talk about the law, and our hearts are still as prosecutors. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Friday nights are like the best for me because I don't have anything else to do.
Yeah, it's not like I'm going to go out, you know.
I'm not going out. I'm tired from the
Go
week.
watch television, go
But
sleep.
I'm less tired. Oh my gosh, you know what I started watching? Like, I watched literally 3 minutes of it because if I start it, then it'll be on my queue and then, like, I'll know to watch it.
Uh-huh.
I've been meaning to watch it ever since I moved here. Bama Rush.
Oh, wow. Yeah.
Have you watched it?
That's something.
Did
I
you
lived
watch it?
I didn't have to watch it.
That's fair. That's fair. You
I
did
remember
live
it.
it.
Pluto TV has thousands of free movies and TV shows.
We're coming at you with everything we got.
This is the mindset.
Free.
This is the mantra.
Free.
This is the mindset.
With movies like Pineapple Express, the entire Star Trek film franchise, and Gladiator, and TV shows like Survivor, SpongeBob SquarePants, The Fairly Odd Parents, and Ghosts. Pluto TV is always free. Pluto TV. Stream now, pay never.